right, well, welcome everybody. My name is Kerstin Henze, and I am the managing attorney of the West Coast office for the firm, which is located here in Tampa. But we do service clients throughout the state of Florida. I've been with the firm 14 years now, exclusively practicing in community association law. So with that said, let's go ahead and can you start the slides, Jeff?
Yes, ma'am.
Awesome. Thank you.
You've
All
got
right.
it.
So what we're talking about today is guest restrictions, screening, tenants, owners, and occupants. Okay. All right. Next.
Oop, wrong way, wrong arrow. There you go.
Jeff is going to be screen sharing, so he's going to be managing the slides today. All right. So what can we even restrict? Okay, when we're talking about controlling, who is occupying or who is coming to live into your community, we need to have the authority to control. Okay, so we need to go to your governing documents with regard to the screening and the application process for buyers, tenants, and occupants, additional occupants. Okay. And that's because really Florida statute, whether it's 718, 719, or 720, that don't really address authority to control purchases, leases, or occupancy in the community. Okay. So in terms of your governing documents, you have really three major documents. Okay. You've got the declaration of condominium. If you're in a condominium association, you have your declaration of covenants. If you are in a homeowners association governed under Chapter 720, and then you have your articles and your bylaws. Okay. Now, in terms of the hierarchy of your governing documents, your declaration of condominium or declaration of covenants is going to be your supreme document, right? It's your constitution. It is the contract between the association and the owners that purchase a property within your community. So it's the declaration that's going to contain your use restrictions. So when we're talking about authority to approve or disapprove, whether purchasers, tenants, or additional occupants, it's the declaration of condominium or covenants that needs to contain that authority. Okay, it should not be contained in the articles or the bylaws. Now, the articles and bylaws, they really set out the corporate structure of your association. So as you may know, your association is a not-for-profit corporation that is governed under Chapter 617 of the Florida statute. And then depending on whether it's a condominium or a homeowners association, then you'll also be either governed under 718 or 720. So the articles will set forth, who qualifies as a member of the association, who qualifies as a director, as an officer. And then the bylaws really are an extension of your articles of incorporation. They'll just have a little bit more detail. Okay. So if there is ever a conflict between the articles and the bylaws, it's really the articles of incorporation that's going to control. Okay. And then lastly, you might have rules, regulations, or policies. Those are not considered part of your governing documents. Okay. So with rules and regulations, you want to make sure that you have the authority in your governing documents, in your declaration, articles, or bylaws to adopt rules, whether it's concerning common elements, common areas, and especially concerning units or lots. Okay.
Okay.
Now, once you've confirmed that you have authority to approve or disapprove buyers or tenants or occupants, then you want to check if you have these additional provisions. And I've just named a few that are relevant for this particular webinar. So confirm if you have the right of approval, right of first refusal. Now we'll talk about right of first refusal momentarily, but that primarily has to do with approving or disapproving purchasers. Okay. Do you have the ability to charge an application fee or a screening fee? Okay. That has to be specifically set forth in your declaration. Now, Chapter 718 of the Florida statute for condominiums specifically limits the amount that you can charge for an application fee in connection with the purchase or a lease or even occupancy. Okay, and it's currently set at $150 per applicant. Now, spouses are considered an applicant, single applicant, and then parent, dependent child are also considered a single applicant. Okay, but the authority to charge that fee has to be set forth in your governing documents. Okay, now typically, if we have a client that doesn't have that authority and they want to have that authority in your documents, and we are asked to amend the declaration to give them that specific ability to charge a screening fee, we typically won't identify the application amount in the declaration. Rather, we will just add language that gives the board the authority to charge an application fee up to the maximum amount allowed under the law as amended from time to time. This way, should the Florida statute change in the future, well, that new amount would automatically apply to the community without having to amend the declaration every time the statute changes. With homeowner associations under Chapter 720, there is no specific amount set forth in the statute, so you'd want to amend the declaration to, rather than identify a specific amount, also give you just the discretion to charge that fee up to the maximum allowed by law in case the statute does change. Now, check your governing documents to see if you have the ability to also require security deposit, and this will be specific only to leases. So if you allow leasing in your community, okay, and you want the tenant to provide a security deposit to cover any damage to your common elements or to the common areas, then you will need specific authority in your governing documents authorizing you to charge that security deposit. Now, with condominiums, the statute does limit the amount that you can charge for the security deposit up to the maximum of 1 month's rent. There is no limitation currently in Chapter 720, but again, you'd want to amend your declaration to give you the authority to charge a security deposit up to the maximum allowed by law. So if Chapter 720 does change in that regard, you're covered there. Do you want to require buyers to deposit or make a certain down payment amount towards the mortgage? Then if so, that's something that either you have to confirm authority in your governing documents, or you might consider amending the documents to give you the ability to require certain down payments for purchases. And move in and move out deposits. If that's something that you are interested in charging, again, that's something that you would need authority specifically in your declaration to avoid a potential legal challenge. All right, next slide, Jeff. Okay, so what transfers are subject to board approval? Okay, well, you have your typical traditional arm's length sales, right? You've got a purchaser, a buyer, a purchase sale contract. These are your traditional sales that are typically subject to approval if authorized in your governing documents. But there could be other types of conveyances that don't really fall in that traditional definition of a sale. They might include gift transfers, which typically are done by quitclaim deeds. So, for example, if a unit owner wanted to add a new spouse to the deed, or a unit owner wanted to add a sibling or a child onto the property, typically those types of conveyances are done by quitclaim deeds, and they would be considered gift conveyances. Now, you might also have life estate deeds where a unit owner wants to keep a present life estate interest in the unit, but upon death, title in the unit or the property might then go automatically to whoever the owner designates. Typically, these individuals are called remaindermen in legal terms, but basically you identify in the deed who are going to be the beneficiaries of title in your unit upon your death. Okay, those are called life estate deeds. You might also see conveyances to trust, to living trust, which are typically done for estate planning purposes. So unit owner conveys title to a trustee, typically with revocable trust. The unit owner is also the trustee for as long as the owner is alive. And then upon death, title in the unit will then convey to the beneficiaries of the trust. So these conveyances done for estate planning purposes are typically, gift transactions. You might also have devises, inheritances for properties that pass outside of these traditional conveyances, so by will. Then you have transfers by operation of law. Okay, if the unit owner dies intestate, or there's a dissolution of the entity that holds trust, if there's a dissolution of the entity that holds title in the trust, or if there's a merger of the entity or foreclosure proceedings. So these are all different types of conveyances that either your governing documents currently allow you to approve, disapprove, or that you might want to consider approving or disapproving depending on the community and the circumstances. Okay, now mortgagee exceptions. Typically, if you do currently have authority to approve, disapprove sales or leases, typically you'll find, especially in the older governing documents, exceptions for mortgagees. So lenders that take title through foreclosure. Okay. Now, typically those conveyances are exempted through from the approval process, because really there is no practical mechanism by which you can screen a mortgagee, right? But once the mortgagee takes title to the property, they're considered an owner just like any other unit owner. And then what if that mortgagee wants to convey title, sell the unit to someone else, or lease the unit? Okay. Do your governing documents exempt those specific transactions from the approval process? Some of the older documents might. In my opinion, they shouldn't be exempted. Okay. So, check with your legal counsel. If you want to have those conveyances also go through the approval process, then you might need an amendment to your governing documents. Okay. Leases. Again, these are also transactions that could be subject to approval, whether you currently have the authority or you might want to consider adding authority to your governing documents. Additional occupants or family members. So typically that refers to once the owner, has purchased the unit or the lot and they've gone through the approval process. And typically they will have identified in the original application who are going to be the occupants of the unit or property at the time of purchase. And let's say some time goes by and someone else moves in to the unit. Okay. Do you want to have those additional occupants, whether they're family members or not, also go through the approval process? Do your governing documents currently provide for authority to approve these individuals? So these are some things you might want to think about. Are you having issues with additional occupants or guest occupants in your community? And if so, then speak to your legal counsel. You might need then additional language to capture those individuals in the approval process. With guests, just like with additional occupants or family members, is it important to you that the owner be present in the unit if you want to allow these additional occupants to also occupy the unit? Are you going to want to allow additional occupants, guests, family members to occupy the unit when the owner is not present? And I don't mean, when the owner goes out, on a cruise, or, if the owner's a snowbird and the owner's not present for, a couple of months. But so, consider what the situation is in your building, in your community, with guests, additional occupants, whether you have the authority to screen or not these individuals, and whether you want to do that. Okay. All right, next slide. All right, so now you've confirmed, let's say, that you do have the authority to approve or disapprove, let's say, buyers and tenants. Okay, well, what can you do? So the screening process typically starts with an application, right? And if you're a community that is managed, through a management company, or you have an on-site manager, typically they will have some form application that you can provide to a buyer or a tenant to complete. And the application will typically have information about, identify obviously the name of the individual and every occupant that's going to be residing in the unit with the owner or the tenant. There's going to be information for residential history, for character references. If you want to have these individuals screened for, criminal background or for financials, then they'll need to consent to the background screening. So once the applicant has completed the application, you will typically submit it to a third-party screening provider. Okay, they'll run the criminal background and the financial or credit history report. And then once you receive the information, you will review it. Okay, and then make a determination to approve or to disapprove the individual. Okay, so one option, if the application and the background check, checks out, then one option would be to approve the transaction. Okay. If we're talking about a sale, typically governing documents require that a certificate of approval is recorded with the deed in the public records. With leases, there's typically no requirement to record the certificate of approval since leases are not recorded in the public records. Now, another option could be to disapprove the transaction based on good cause. Okay. Now, if you're going to disapprove for cause, okay, strongly recommend that you have the good cause criteria expressly set forth in your governing document, specifically in the declaration. And if you don't, okay, presuming you have rulemaking authority, that at the very minimum, you adopt good cause criteria by board rule or policy, if you have that authority in your governing documents, okay? Now, some of the good cause criteria I've identified here. And the reason you want to have these good cause criteria specifically set forth in your governing documents or as a policy or as a rule is because if you do end up disapproving an applicant, okay, and the owner challenges the disapproval, then you want to be able to say, well, these are the criteria upon which we disapprove, and the applicant just didn't meet that criteria, okay? This will especially be helpful if the applicant claims some form of discrimination in the application process, okay? Now, some of the good cause criteria that you might want to consider adding, if you don't already have, is negative criminal history. Now, this is a big one. With negative criminal history, so you want to be careful. And typically I encourage clients to, seek legal guidance when reviewing, a criminal background report, okay? Because typically misdemeanors or arrests or charges in and of itself are not good enough basis to disapprove an applicant. Okay, so you want to make sure that there's at least a felony, okay, and there has to be a conviction or a guilty plea. So again, arrest or just a charge on the background report will not suffice as a good cause basis for disapproving this applicant, okay? So generally you'll want to consider the nature, the severity of the offense, and how long ago did this offense occur, and then any rehabilitation efforts. Okay, so with criminal history, it's really going to be on a case-by-case basis, depending on what the report reflects. Okay, now negative financial history. If you run a credit report, typically any collection actions would be reflected in the report, prior bankruptcies, debt to income ratio. If there's a lot of credit card debt, that would be reflected on the report, and a credit score. Now, one of the good cause criteria that you can adopt is a minimum credit score that the applicant will need to meet in order to purchase or lease in your community. With credit score, we typically do not recommend, if you are amending your documents, we do not recommend that you expressly identify the credit score in your declaration, because depending on market conditions, you might want to change that credit score, right? And so rather than setting forth the credit score in your declaration and then having to amend it every time you want to change it, we typically recommend clients just having the amendment specifically just give you the authority to adopt a credit score by rule or policy. And that way you can then modify that credit score at a board meeting, okay, without having to get membership approval to amend the declaration every time. You might want to also include in your declaration the authority to request income tax returns, pay stubs, and any other financial documentation that you feel is reasonably necessary to make a determination as to the viability of the applicant to purchase into the community and pay his or her monetary obligations to the association, right? Assessments and any special assessments that might come due. Now, another good cause criteria could be a violation of the governing documents on its face. So what that pertains to is if on the application, let's say you have a statement that says no pets are allowed, or you've requested the applicant to identify, do you have pets? And you have a no pet community, and this applicant has checked off that yes, he or she has a pet. Well, clearly on the face of the application, this applicant is going to be in violation of your governing documents, okay? So that could be a basis to disapprove, okay? And certainly if there's any false information included on the application. What I've seen typically is on the question of, have you ever been convicted of a crime? Sometimes the applicant will check off no when the criminal background report reflects otherwise. Okay, so in those instances, rather than immediately disapproving, I encourage you to go back to the applicant and just get some clarification, okay, and then make your determination. Okay, so we've talked about the option of approving the transaction, disapproving the transaction if the applicant just doesn't meet your good cause criteria, okay? And then the third option is if you disapprove for reasons other than good cause, okay, then you will likely have the requirement of exercising a right of first refusal, okay? And what that means is, and this specifically pertains to sales and conveyances. So under Florida law, So we're talking about the exercise of right of first refusal. So with regard to sales and transfers, if you're going to have governing documents that authorize the association to approve or disapprove these transactions, then Florida case law says that the association also has to have a corresponding obligation to provide a substitute purchaser if the board disapproves a sale or transfer transaction for reasons other than good cause. So a good example would be if, let's say, the board gets a criminal background report on an applicant, and while there are no convictions, okay, of any felonies, there's a few misdemeanors and there's a lot of traffic violations. Well, this particular board does not want to approve this applicant, okay, based on this particular criminal report. So let's say, even though I've already given the client the opinion that it's not a good basis to disapprove, based on this report, the board decides to go ahead and disapprove anyways. Okay, well, what practically will happen when the board issues that disapproval letter is that the attorney for the owner, okay, because it is the owner that has standing to legally challenge a disapproval, the attorney will then make a demand on the association to provide a substitute purchaser. Okay, whether it's an individual, a third party, entity, or it could also be the association. Okay, and that substitute purchaser essentially would have to purchase the unit under the same terms and conditions as the original offer for purchase. Okay, now you have to have that language of right of first refusal and obligation to provide substitute purchaser in your declaration in order for your sale approval provision to be valid under the law. So some of the older documents, if you just have the authority to approve or disapprove without this additional right of first refusal language, then your entire sale approval provision is subject to successful legal challenge. Okay, so then speak to legal counsel about amending that provision to make it in accordance with Florida law. Okay, now with leases and occupancy, there's nothing in the law that specifically requires an association to provide a substitute tenant or occupant if you disapprove for reasons other than good cause. That said, you might have language in your original declaration that requires the association to provide a substitute tenant or occupant in those instances. Okay, so when we typically see that language, we would recommend the client to remove that by amendment. Okay, so speak to your legal counsel on these particular issues. Now, one thing that you will also want to make sure when you are reviewing an application is to check your governing documents on the specific time frame provided in your documents as to when you have to render a decision. Okay, because if you don't provide a decision, okay, especially if you are inclined to disapprove the application, then your governing documents might say that the application is deemed approved, right? Unless you disapprove it within a certain time frame. Okay, so you want to make sure that you are that you comply with the time frames in your declaration. All right, next slide. All right, so potential liability. So for sure, you cannot deny an application based on a protected class. And under fair housing laws, because Fair Housing Act is what applies to community associations, not the Americans with Disabilities Act. It's fair housing. So under fair housing laws, there are certain protected classes, and I've identified here just a few. Okay, race, national origin, familial status, sexual orientation, marital status, and depending on the county where you're located, there could be additional protected classes. So you want to make sure that if you're disapproving an application, you're not disapproving based on a protected class, because that will surely subject you to a fair housing violation. Okay. Now, you also want to make sure that you don't disapprove an application if the applicant has made a request for either an accommodation or a modification. So a request for modification, let's do accommodation first. A request for accommodation is when the applicant is requesting the association to make an exception to a rule or a covenant, restriction, okay? So the most common example is pets, right? If you have a community that prohibits pets, and this particular applicant, whether it's a purchaser or a tenant, has an emotional support animal, has an assistance animal, and has submitted a request for the association to allow the applicant to keep this animal, okay? That would be a request for accommodation. When you get a request like that, okay, our recommendation is not that you immediately deny, absolutely not. On the contrary, that you take whatever the documentation was provided, review it, make sure that it meets basically, the requirement under the law for the association to grant the accommodation. Okay, I'm not going to specifically address, what those requirements are. We do have another course that we teach on fair housing laws and, accommodations and modification requests. Okay, so if you do get a request like that and you're just not sure whether it meets the criteria, then speak with your legal counsel, okay, who can assist you in evaluating the request. Okay. Now, a request for modification is if the applicant is requesting, is making a request to modify the common elements or common areas because the applicant has some disability, right, and needs that modification in order to be able to properly use the common elements or common areas. So a good example is if the applicant is wheelchair bound and the applicant needs to install a ramp to get to the unit. Okay, that would be a request for modification. Okay, so if you get any of these requests, just evaluate them with your legal counsel. Notification requirements. Again, I just kind of briefly mentioned. Make sure that you review your declaration to make sure what the time frames are for notifying the owner of the decision of the board whether to approve or disapprove. Typically, most documents I've seen 30 days from the date of when the association has received a complete application package. And that would include once you've received the background reports from your third-party agency. Okay. Now, when you do, when you decide to, once you've made a decision, if you've decided to disapprove the applicant, okay, be very careful of how you word your disapproval letter, okay? And the reason is because under Florida Statute 718 and 720, as well as under Fair Credit Reporting Act, any information, documentation that you have obtained in connection with your sale, lease, transfer, okay, or any information obtained from these background reports, they are required to remain confidential. That means you cannot disclose a copy of the credit report or criminal background check with the applicant or the owner, and it's certainly not open for inspection. Okay, so when you draft your disapproval letter, we typically recommend that the only reason that you disclose on the letter is that the board has disapproved the applicant based on the failure of the applicant to meet the criteria or qualify under the governing documents. Okay. Now, with the credit report, you will want to put on your disapproval letter the name, you identify the name and the contact information of the agency that provided the credit report. Okay. And if the applicant wants to, the applicant could contact the agency and get a copy of the report and then evaluate the information provided on the report. Okay, it's not up to you, nor should you be disclosing those credit reports. Okay, now typically governing documents will require the association to only notify the owner of the disapproval. Okay. I am aware that some counties do require the association to specifically notify the applicant of the disapproval, okay? Particularly Broward County Association has 45 days from the date of receipt of a fully completed application and background reports to notify the applicant of the disapproval, okay? So you'll want to make sure that you check with your local county, make sure there's no other requirements. Okay, next slide. All right, and then guest occupancy. These are typically the more problematic types of occupancies that we face with communities, right? Because they're not purchasers, they're not tenants, and typically governing documents don't address these additional occupants, right? So if you do want to restrict some form of guest or additional occupants in your community, then you need to think about how you define them. Okay, are they going to be deemed tenants and then have to go through the approval process just like tenants do in your community? How long do you want to allow them to occupy before being screened? How long do you even want to let additional occupants or guest occupants occupy a unit in the community when the owner's not present? Can it only be when the owner is present? Okay. Do you want to add any specific exceptions to immediate family members? So if you're an immediate family member of the owner, you can visit for an extended period of time before getting board approval. Can these immediate family members occupy a unit in the owner's absence? Or do they have to get approval after a certain period of time? Okay, these are just some considerations that you might want to think about and discuss with legal counsel when developing the language for your documents on guest occupancy.
Hey, Kerstin, when you and I
Yeah.
first met and I got to know the firm, I was working with a very large 55 and over community. How different, like some of the bullet points you're going over here, are they radically different when it's a 55 and over, or is it pretty much the same thing? Like, are there any considerations that the board has to make if it's a 55 and over?
I mean, they're typically the same. The thing with 55 and older communities, provided that you have language in your document specifically stating that you are a housing for older persons
Right.
community, and provided you meet all the other requirements under Fair Housing Act, you can disapprove applications or occupancies based on certain age.
Okay.
Okay. Which age is typically a protected class unless you're housing for older persons. Okay. So I would just get with your legal counsel if you're housing for older persons
Okay.
community.
Thank you for clarifying.
Okay. And then next slide. All right. So just some additional practical considerations. If you don't currently have authority to approve the transactions or occupants that we've just discussed, then you might want to consider doing a community-wide survey. Pose the question to your members. Is that something that your members might be in favor of? Because eventually, any amendments to your governing documents will have to be presented to the owners and have their approval. Okay, so before you spend the time and the expense of drafting, amendments to your documents, pose the question to the owners. What would they be in favor of? Lease renewals, is that something that you want to also approve or disapprove? Or is every lease, even if it's with the same tenant, is it going to be treated as a new lease and you're just going to have to enter into a new lease? Screening additional occupants, we've already discussed. Use of facilities and common elements. You might want to consider adopting policies and rules about use of facilities by guests. Access control, vehicle registration, key code fob systems, gate access, front door procedures. Once you have the specific authority in your documents with regard to these purchasers and tenants and occupants, then consider adopting additional rules and policies regarding, access control and registration, including vehicle registrations.
So glad you went over that because a lot of folks confuse the docs with R&Rs and everything. So that's good information.
And then finally, enforcement. So if you have, typically a tenant or an occupant that's just not complying with the governing document, typically those types of violations are addressed through arbitration and mediation. Okay. Now, if you're talking about, wanting to compel the removal of a tenant or an occupant from the unit, you want to force them out of the unit, that is something that can be done initially through litigation without having to arbitrate or mediate that particular dispute. Okay. Now, if you are, if you want to be able to compel the removal of a tenant, look in your governing document, see if you have the ability to evict the tenant. Okay, this is language that's not typically found in some of the older documents, but you might need to amend your declaration to give you this authority. And essentially, it would put the association in the shoes of the owner, okay, and allow the association to bring a direct eviction action against a tenant and evict the tenant, okay? And if you have the ability already to approve, disapprove tenants, you will have already a copy of the lease in file, okay? So you'd be able to evict with the lease on file. And eviction is typically a much quicker process through the court system than a lawsuit that you file against the owner to force the owner to evict the tenant. So you want to have the ability to evict. And then, the ability to deny access to the property or use of the common elements. You have the ability, both 720 under 720 and 718 of the Florida statutes, to suspend use rights to common elements in certain facilities if the owner or the tenant or occupant are in violation of the governing documents or rules. Okay, I'm not going to specifically address the procedure for doing that, but that certainly remains an enforcement option. Okay. And in summary, you want to confirm, again, your authority with regards to purchasers, tenants, and occupants. And if you don't have the specific authority that you want, then consider amending your governing documents to give you that authority. You want to establish procedures and proper documentation. So, what is your application process going to look like? What forms are you going to use? Okay. What would be, what is your policy for good cost criteria if there are not already set forth in your governing documents? You want to act uniformly and consistently, okay, with any application that you receive. Now, who do you want to be the authority for approving or disapproving this application? Do you want that to be on the board? Do you want the board to take that action, or do you want to delegate this authority to a screening committee? Okay, so if you want to delegate this to a screening committee, then check your bylaws, see what committees you can form, who can form them, and then speak to legal counsel about drafting a resolution, okay, to create the committee and to delegate certain authorities to these committees. And then finally, again, understand the purpose and the extent of your documentary authority. So know the limits of what you can and cannot do, okay, with this authority. All right, and I think that concludes this presentation. Let's see here, starting from the top. So we have a question: to amend the governing documents, does it require membership vote? So typically, yes. Now, depending on which document you want to amend, you have to look at that particular document to see what the specific voting requirement is. So if you're amending the declaration, you got to look to the amendment section of the declaration to see what's required to amend, okay? And so forth and so on. In terms of rules, they're not part of your governing documents, but if you're going to adopt any changes to the rules, you need to also confirm with the articles or your bylaws if you can amend by board vote only, or you need membership approval. It's not uncommon, and I have seen documents that specifically say membership approval is required to amend rules. Okay. Let's see here. Is a background check necessary for a renter? Let's see. Yeah, I'm just having all these technical difficulties today. I give up.
Would you like me to read the, you want me to do the reading? And if it's not a pertinent
Hold
question?
on, I got it. Is a background check necessary for a renter? Well, it's not necessary and certainly not required unless your documents provide you with that authority. Couldn't we do a free online criminal background check? I mean, I'm not aware of any online services that do free background checks. So I would just be careful in relying on the information. It might not necessarily capture, the entire criminal background. In fact, I've come across instances where, client pays for a third-party servicer to do a criminal background check. And typically those should capture criminal records throughout the United States, and it doesn't. Somehow it doesn't. And so when I've gone into the local court system and I pulled criminal records, so you want to make sure when you do engage a third party that they do a thorough review.
And also be aware of anything that's free, right? Sometimes
Right.
the information on free stuff is collected for marketing purposes, and then all of a sudden you're getting a bunch of emails from people you never heard of.
Right. And it could be a limited search too. So just be aware. Let's see. From my understanding, it's only service animals. Can you clarify? Well, under Fair Housing Act,
Well,
the
he
term,
two questions under, he followed up to his statement. He said they have an emotional support goat.
support goat. Oh boy, that's definitely beyond the scope of this class. But service animal can only be a dog. Let's see. Property is occupied before the application and a review process takes place, which is in violation of the documents. Options available: find any other option to correct the situation and avoid recurrent problem. All right, so in this particular case, you've received the property is occupied before the application process. Well, it depends. If we're talking about an owner, what would typically happen in that case is that, you can still submit or make a demand for the owner to submit an application and go through the approval process. But if the owner refuses, then your options are limited because the owner already has title. And so if if this individual is someone you absolutely do not want to live in the community, then you have to consider, filing a lawsuit to potentially void title. And that, that can be complicated. So you'll have to speak with your legal counsel about that option. But if it's a tenant or an occupant and they don't submit an application after you've already made numerous demands, one option can be to file a lawsuit against the owner to force that tenant or occupant out, unless you have the ability to evict. But yes, certainly you can also consider fining. And you can also consider suspending use rights to certain facilities if you have the ability, obviously, to control access. Otherwise, that's not going to be a viable remedy for you. Let's see.
Let's do a couple more. I know we're already past the time, but I know we also had a couple of technical glitches. So let's do a couple more questions, if that's okay with you, of course.
Yeah.
Okay.
So for condo associations, what is the received by date for completed application for sale or lease? Check your documents, but typically an application is considered complete when you not only have the actual physical application, but you have your background checks already received. You have, any other, supporting documentation that you've requested, bank records or tax returns. When you basically have all the information that you need to then sit down, review, and make an evaluation. Typically, if this documentation is submitted to management company, well, your manager is considered an agent of the association. So the time will start ticking if your manager has received the completed application. And then again, you'll need to check your documents to see what is the time frame within which you have to render a decision before the application is deemed approved. Let's see. Is there a definition of immediate family? Well, you'd have to look at your documents to see how your documents define immediate family. And if they don't, and this is something that you are amending, then yes, you will want to specifically define who immediate family members. Is it just, typically it's the parents and siblings and children, grandchildren, but if you want to add additional family members, you can by definition through an amendment process. So I've got a question. If there's a new owner who purchased a property in an auction, do they need to be screened? So, that's very specific to the documents of this community, but typically these types of purchasers are exempt from the approval process because again, there's just no mechanism to practically screen these applicants, right? When they purchase property through an auction, foreclosure sale, this is done electronically, right? So there's just no mechanism to do the approval process. However, check your documents to see if when that particular purchaser then, decides to rent or decides to convey title, do they have to go through the approval process?
Let's do one more, and then I'll go over the evaluation process one last time. And folks, if we don't get to your questions, please don't take it personally. We have tons of them here in a limited amount of time. You'll be able to put a question or a comment into section 10 of the evaluation. And if you require assistance or would like to inquire with Kerstin about how KBNR may be able to help your association, check that box on the evaluation as well, and then you'll get contacted.
The process of putting a cap on the number of owners that can rent when not in place now. So if your community is considering putting a cap on the number of units that can be leased at any one time, you can do it by amendment. That would be the only way to institute a cap. So you'd have to have an amendment drafted, and then you'll need to most likely present it to the owners for membership approval. And then once that amendment passes, then you need to record it in the public records. Now, I'm not sure if this is a condominium. I'm going to go with yes. Just remember that with condominiums, really in HOAs too, if you're going to put a rental cap, then the statute says that such an amendment is only effective against those owners who vote in favor of it and those who take title after the effective date of the amendment. So just be careful of the application. And it's a little bit more of a complicated analysis if you have a certain language in your documents called Kaufman language. So speak with your counsel how that statute would play out and how it would apply to your community, depending on whether or not you have Kaufman. So I'll just leave it at that.
Sounds good. And I know you have an appointment coming up that you have to get ready for. Before you head out, can you please tell everybody the best way to reach you at your location?
Yes, thank you so much for attending, and I apologize for this technical glitch earlier. But yes, you can reach me at via my email, which is right here on the screen, or just call the main office number 954-928-0680.